the 24th of May, 2025, residential neighborhood, Wellingford and Shepherd Avenue, Florida. A 20-year-old male was found shirtless, shoeless, in possession of a neighbor's mail. Observed accessing multiple residential mailboxes while visibly impaired. Police were called.
And he stopped in our driveway. For some reason, my wife was out there with the dogs. So she came and got me, and we started talking to him. This is from Leeward, right around here. We were going to take it and put it back in their mailbox. But he had that in his hand, and he was going through other people's mailboxes, too. He's high as he could be.
Gotcha. Hey, man. What's your deal?
I'm sorry, I was at my friend's house last night. I know, I snuck out at my parents'. I still have to...
How old are you?
I'm 20.
20? Do you have a license on you? Take your hands on it.
Yeah. First name's Seth.
S-E-T-H?
Yes, sir.
Middle initial?
I don't have one.
Okay. Alright. So, what are you doing?
I need to let my parents know that I was out the other night.
Alright, hold on. Before I go too far, just because I'm interacting with you and I have no clue what you're doing out here, I'm going to read something to you, okay? You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before I ask you any questions and to have one present during any questioning. If you cannot afford a lawyer, one will be appointed to you before any questioning if you wish. If you decide to answer any questions without a lawyer present, you will have the right to stop answering at any time. You also have the right to stop answering at any time until you talk to a lawyer. Do you understand these rights that I read to you? Alright, and with these rights in mind, do you mind telling me what's going on today? Yes?
Yeah.
Okay, so what's going on, dude?
I just need to have a seat for a little while, just because...
Alright.
He was going through, he didn't go through ours because my wife was right there in the driveway, but our neighbor, he opened hers.
Okay.
And so I'm sure he opened others too. And obviously he has that mail from people in Leeward.
Alrighty. Well,
did you tell him what you told me, Seth? What were you looking for? When you were getting the mail out of people's mailbox, do you remember what you told me you were looking for?
alrighty. Do you have your license on you, boss?
No, I don't.
Alright, you're good.
I have mine in my car if you want it.
Sure. Yeah. And, after I get you guys logged in the call, y'all are good to head on out. I'm gonna talk to Seth and figure out what's going on. Do you suffer from any medical issues? Yeah. Alright. What friend's house were you at?
My friend Logan's. If I could just sit in your car and just let them get home, and I'll speak to you about everything that happened.
Alrighty, folks. Y'all are good to head on out. Thank you.
Thank you.
Go ahead. Alrighty. So, what else is going on, dude?
My friend told me that I should have gone back earlier. I didn't drive or anything like that. I snuck out the other night, and I was gonna stay with my friend Logan. He told me to go back home. So I went back home, and then I was gonna tell my mom and everything, but
I mean, you're 20, right?
yeah.
So you don't really have to sneak out of your house if you're an adult.
Yeah.
You under the influence of anything? No alcohol, no narcotics. Or are you going through people's mailboxes? Do you have an answer for that, or? Is that a normal thing for you, or?
No, I just...
Are you good? Tell me what's going on, dude. So, gotta give me a good reason for why you're wandering around in a neighborhood that you don't live in, going through people's mailboxes. Do you need medical attention? You have no reason. Alright, well, you're not making any sense. Do you understand? How are you getting home?
My friend was supposed to bring me right back the other night from his place, but I just...
Just what? I mean, I'm not going to stand here while we just have awkward silence, so whether you give me a good excuse on why you're walking around in a neighborhood that you don't belong in and going through people's mailboxes, or we're going to have to go a different route, so... Put your hands back. I'll let you figure out what you got going on. You're not under arrest, you're just being detained. Central, I have one resisting. Get on your stomach. (10-4) Delta 48, Wallingford and Shepherd Avenue. This stupid. One Delta 48. You could clear the air, have a doll panel, and 15.
What happened?
And go to just detain him, told him he's not under arrest, and get one cuff on, turns around, starts trying to pull away. Cuff gets all locked in my
Are you hurt?
finger, like a little scratch, and then he starts pushing away from me, so I
Did he hit you?
brought him, assisted him to the ground. Now, right. Stupid.
Stuck on teletype, so.
Yeah.
You read?
Yeah, I had read him because I was thinking LMP. It's not giving me any fucking reason why. Somewhere off of Worthington, but he's shirtless, shoeless, going around, going in people's mailboxes and taking mail out. No reason at all.
Not real?
throw a punch or anything.
He punched you?
No. It was mainly just
Yeah, but did he push you?
he like braced on me. He was more LMP because I had no clue. He wasn't giving me a reason why he's going around like during the daytime going through people's mailboxes and I had read him to begin with. He's not saying no. He said yes, but he's not saying anything. Like he would just like stop talking and just stare at me. OMP and resisting.
How do you not have that Leo if he pushed you? You get what I'm saying?
Yeah.
Would it be resisting with violence?
No, because it was more of an invasive, like, he turned around and was, like, trying to brace away from me. So, yeah, so it was definitely active resistance. I mean, but wasn't sure if it met that threshold.
You should leave that in your car.
I'm sorry, I'm 21 today, but can I clear with X-ray 10 on that too?
ISSU, 1 lawful detention, Terry versus Ohio, 392 U.S., 11968. An investigative stop requires only reasonable articulable suspicion, not probable cause. Eyewitness account of mailbox tampering plus physical possession of another's mail equals Terry threshold, clearly met. ISSUE 2 federal criminal exposure, 18 U.S.C, section 1708 theft of mail. Stealing or abstracting mail from any authorized depository is a federal felony up to 5 years imprisonment. Physical possession of mail bearing another's address constitutes prima facie evidence of section 1708, independent of witness testimony. ISSUE 3, Miranda during detention. Miranda v. Arizona 384 U.S. 4, 361966. Miranda warnings are constitutionally required only before custodial interrogation, not during a Terry stop. The officer administered Miranda early, citing LMP evaluation, likely mental patient, as the operative concern. Early advisement is not a legal error. It protects the evidentiary record across multiple legal pathways, criminal arrest, or Baker Act referral. ISSUE 4 silence and 5 TH amendment, Bergwis versus Tompkins, 560 U.S. 370201. Mere silence does not constitute an unambiguous invocation of the right to remain silent. A suspect must explicitly and unambiguously invoke passive non-response, does not obligate officers to cease questioning. The subject's prolonged silence created no Fifth Amendment bar to continued questioning under Tompkins.
Oh yeah, they are 2 separate. I can still do without and then that. Yeah.
Yeah, I would do the without and then without.
For some reason, I was only thinking like hand in hand, basically.
Do you feel comfortable doing the report?
Yeah.
You gonna do that on P2 because he tried to take flight?
Yeah. I wish I would have got a statement from B because he didn't want to talk with the people that stopped him. You don't think I need a statement from them, do you?
For what?
Just that he went into their neighbor's mailbox?
No, you don't. Unless you want to go down there and speak with them, but realistically,
I had spoke to him on scene. I just didn't put him on
for a
paper.
Suspicious person, because why? What did the call note say?
That they had a male who
It appeared to be under the influence of
appeared
narcotics.
to be under the influence of narcotics going through mailboxes. That Leo?
Yeah, you can show it.
My partner said that you said some like suicidal statements. What'd you say to him so I could tell the jail? Just that you're feeling depressed or something? Okay. But you didn't say like you're trying to kill yourself or... Okay. Alrighty. We're off. One up. Here. What's up, fool? Have a seat on the bench. Definitely not a good way to start out a criminal background. A felony and 2 misdemeanors. You could go in for a Baker Act or something like that, but acting sketchy and then trying to run away. I was literally like, you were just being detained, and I told you were under arrest. Yeah. And then I don't know if that was your cry for help, like, or what was going on, but. Just glad it was all open hands and we didn't have to sit there and go back and forth. So.
ISSUE 5 Baker Act Mental Health Pathway Florida Statute Section 394.463 authorizes involuntary psychiatric examination when a person presents a substantial likelihood of harm to self or others. No criminal act is required as a predicate. Disorientation reported suicidal ideation, and inability to account for one's behavior independently satisfies Section 394.463. Criminal charges and Baker Act examination are not mutually exclusive. Both can proceed from the same incident. ISSUE 6 U.S.C. of Force Graham v. Connor 490, U.S. 386 1989. Force is evaluated under an objective reasonableness standard from the perspective of a reasonable officer on scene, not with hindsight. 3 controlling factors. 1. Severity of the crime at issue. 2. Immediate threat to officer safety. 3. Active resistance or flight. All 3 factors were present at the moment of the takedown. ISSUE 7 Felony versus Misdemeanor Resistance Florida Statute Section 843.01 versus Section 843.02 Section 843.01 Resisting with Violence, 3rd degree felony up to 5 years. Requires force directed at the officer. Section 843.02 Resisting without violence, 1st degree misdemeanor up to 1 year. Covers obstruction without physical force. Florida courts have held that pulling away during handcuffing can satisfy Section 843.01 if sufficient physical resistance is applied. State v. Espinoza-Gelabert-Fla, 3D DCA 2003. The charge classification turns on the force analysis. Lessons learned 1. Early Miranda advisement during LMP evaluation is a sound evidentiary practice, not procedural error. 2. Silence without explicit invocation does not terminate lawful questioning under Bergwis v. Tompkins. 3. Federal mail theft under Section 1708 carries greater exposure than state-level charges. Prosecutorial jurisdiction must be determined early. 4. Solo handcuffing of a non-communicative, potentially impaired subject without backup creates preventable tactical risk, and in this case contributed directly to the resistance incident. 5. Baker Act and criminal arrest are parallel tools. Accurate legal evaluation requires assessing both pathways before action, as the officer did here.